If you have a loved one who has lost cognitive ability due to ailments such as Alzheimer's disease, dementia, traumatic brain injury, or otherwise, you may find yourself in an emergency situation where you need to step in and assist that person in a crisis. If an emergency hits and there is no legal guardian appointed for that person, it is vital to know that the law provides for this situation and provides guidelines for someone to acquire an emergency guardianship order. Such emergency situations include situations such as unauthorized large purchases made by the incapacitated person, the interference of another person who means to do harm to your loved one, or the insistence of your loved one on putting themselves into a harmful physical or financial position. The law provides the procedure for one to acquire an emergency guardianship. If an emergency exists, or if an already appointed guardian is not performing his or her duties, and the court finds that the welfare of an incapacitated person requires immediate action, the court may, without notice to anyone, appoint an emergency guardian to serve for a limited period of time. As an apparent safeguard against potential abuses, the law also requires that the court must hold a hearing to consider the appropriateness of this action within 14 days of the appointment of the emergency guardian. The ward must be noticed of this hearing, and the court is required to provide the ward with an attorney unless the ward retains his or her own attorney. Utilizing this law can be a necessary and even life-saving tool in appropriate circumstances where a proposed ward is in immediate physical or financial danger. If you find yourself in a situation where an emergency exists, it is best to consult with an attorney who can guide you through the process.